welcome back to this cybersecurity conference organized by UNIDIR. We are delighted to welcome you. We're also delighted to have many of you returning following this the conversations and panels that we had this morning. Let us really now focus on this panel, which is discussing international law in the context of international ICT, peace and security. My name is Cécile Aptel and I'm the Deputy Director at UNIDIR and truly delighted to be moderating this panel with three great panelists. The panel is to discuss how we can build on the past successes of the Open-Ended Working Group and the group of governmental experts, the two UN processes that have been dedicated to advancing international ICT, peace and security. The panel is also for us to look at what should be prioritized in the coming years, particularly in the context of the Open-Ended Working Group 2021 to 2025 on security of and in the use of information and communication technologies. So as we will be focusing on the subject of international law in the ICT context, we can start by recognizing that there have been successes. States have really united in univocally confirming that international law applies in cyberspace. And in fact, the panel that we had just before breaking for lunch alluded to the importance and the links between norms and international law. The consensual report of the Open-Ended Working Group, which was adopted by the United Nations General Assembly earlier this year, is also very clear. Its paragraph 34 confirms that, and I cite, states reaffirmed that international law, and in particular the Charter of the United Nations, is applicable and essential to maintaining peace and stability and promoting an open, secure, stable, accessible, and peaceful ICT environment, end of quote. The final report of the 2019-2021 UN Group of Governmental Experts on advancing responsible state behavior in cyberspace in the context of international security is also clear. The group reaffirmed the commitment of states to a number of principles of the UN Charter and international law more broadly, including sovereign equality, the settlement of international disputes by peaceful means, refraining in their international relations from threat or use of force, respect for human rights and fundamental freedoms, and non-intervention in the internal affairs of other states. Moreover, given the enormous appetite for answers as to how does international law apply to state conduct in relation to cyberspace, the same group of governmental experts added an additional layer of understanding, reaffirming the applicability of and providing some guidance to some principles, including internal sovereignty, international humanitarian law, applying in situations of armed conflict, as well as also mentioning secondary obligation of state responsibility, including attribution and due diligence principle. Again, something that was discussed in the panel that occurred just before lunch. Yet with all of these achievements, this is not to say that the work is done, and many questions on how international law applies remain. The chair summary, the summary of the chair of the Open-Ended Working Group was clear that states indicated further understanding was required on how international law applies to state use of ICTs. Indeed, as the group of governmental experts of 2021, the 2021 report suggests, states need to engage in further discussions and exchanges of views on how specific rules and principles of international law apply to the use of ICTs by states. This will lead to a deepening of common understanding, avoiding misunderstandings, and increasing predictability and stability. Particular issues that have been noted in the relevant UN processes include three. First, some states propose that such questions include, inter alia, the kind of ICT-related activity that might be interpreted by other states as a threat or use of force, referring to Article 2, Paragraph 4 of the UN Charter. or also that might give a state cause to invoke its inherent right to self-defense. Second, it remains to be seen how the principles of international humanitarian law, such as the principles of humanity, necessity, proportionality, distinction, and precaution, apply to ICT operations. Third, the question remains, will the existing international legal framework, coupled with voluntary norms, in fact result in progressive development of the customary law of cyberspace, able to regulate the state conduct in this domain, or do we need a new cyberspace treaty? The debate on this question during the Open-Ended Working Group suggests that states remain split on this question. So it is clearly a welcome development that states are becoming more transparent about their views on the international law in cyberspace. 15 states have contributed their views to the official compendium of voluntary national contributions on the subject of how international law applies to the use of information and communication technologies by states. Additional views have been published by individual states, and we are delighted, as always, as UNIDIR, to have these views accessible on the UNIDIR's cyber policy portal. In light of the outstanding issues that I just, in fact, briefly introduced, to discuss this very topical issue, we're absolutely delighted to be joined today by three very distinguished speakers, and a warm welcome to all three of you. I will introduce you in the order in which also I will address your questions. So starting with Mr. Asset Nusopov, thank you for joining us. Mr. Nusopov is the head of sector in the Executive Office of the President of the Republic of Kazakhstan, and also was a member of the 2019 to 2021 UN Group of Governmental Experts on Advancing Responsible State Behavior in Cyberspace in the context of international security that I largely referred to already. A warm welcome to you. A second distinguished panelist, and thank you for joining us, is Ms. Curly Versky, Director General of the Legal Department at the Estonian Ministry of Foreign Affairs. Thank you again for joining us. And last but not least, we have Professor Vera Rusinova, Head and Professor at the Law Faculty of the School of International Law, HSE Moscow in Russia. And also welcome, and again, thank you to all three of you. Before I direct the questions to the speakers, please allow me to remind the audience to also be engaged, and in particular using the Slido platform. Please submit your questions at any stage as you also hear our panelists. This is true for both the people that are present in the panel today as well as our online audience. I will be collecting the questions during the debate. And so the idea is that we have now about 25 minutes dedicated to the panelists answering questions, and then to try to keep as much time as possible to answer the questions that the audience will be posing. So with this, I'd like to start with you, Asset, if I may. Given your experiences with the relevant UN processes that I have mentioned, how do you think we can leverage the open-ended working group mandate? How can it be leveraged to answer outstanding questions related to how international law applies? Asset?
Thank you, Cecile. Good afternoon, dear participants. I would like to thank the organizers of the conference for the opportunity to address this event. I would say that there was the least consensus on this section during the discussions at OEWG and GGE. So I consider this section to be the most sophisticated panel. So let me start with some general observations. So the first is that the global health emergency showed our reliance on ICT. So they grow very fast, and the adequate legal basis is needed. According to some experts' assessments, average human spends 2/3 of their time online. So currently, I would say that everything has moved into the context. Examples of the context of new reality are selfies, posts, and likes. And I consider that the applicability of international law should be considered in the context as well. So first is the mandate of the new OEWG. So here I provide a brief citation. According to Resolution 75/240 adopted by General Assembly, decides to convene with a view to ensuring the continuous nature of the democratic, inclusive, and transparent negotiation process on security and the use of ICT under the auspices of the UN and new OEWG 2021-2025 acting on a consensus basis to continue as a priority to further develop the rules of responsible behavior of states, to continue to study with a view to promoting common understanding how international law applies to the use of ICT by states. So, in general words, I would say that any doctrine or concept needs to be implemented through norms of law. So I guess the context is exactly in developing common understanding on the application of international law and norms, rules, and principles, which were discussed in the previous section, for responsible state behavior in ICT. I think it's appropriate here to recall GGE report of 2021, which Cecile was currently already introduced to us in her speech. So it adds an additional layer of understanding of how international law applies. And according to the paragraph 71A, so within obligations under Chapter 6 of the Charter of the UN, states should resolve disputes by peaceful means. B is respect for sovereignty. C is principle of non-intervention. D, prohibit to use force. And G is use of proxies. And E says that state has the right to take measures consistent with international law and the need for continued study on this matter. And F is for international humanitarian law, which includes principles of humanity, necessity, proportionality, and distinction. And again, it should be noted that IHL applies only in the context of the armed conflict. I carefully read and advise you to do the same. The official compendium of voluntary national contributions on how international law applies, which included to the GGE report. And I wanted to share some squeezes from it. So I agree with my colleagues who consider that there are still many unanswered questions concerning the precise manner in which international law should be applied in cyberspace. Some countries pointed that there is no international agreed definition, for instance, term of the cyberspace itself. Also, there were provided broad explanation for two related bodies of international law that are relevant to the discussed question and the use of force in and through the cyberspace, which is jus ad bellum and jus in bellum. Some experts noted that the question in current discussion is no longer whether, but how international law applies to the use of ICT by states. Of course, the official compendium, as well as the additional voluntary contributions, national contributions, has many other interesting and informative things on how international law applies to the use of ICT by states, but we don't have, I'm afraid, enough time to discuss all of them. So in summarizing my point of view, I believe that different legal systems, sources, and levels of cyber threats which come from could emerge from individuals, groups, states, definition of certain concepts and issues of responsible behavior, as well as in legal terms, issues of IHL applicability, including proportionality of countermeasures, maybe some practical attribution mechanisms. These all push us to the situation when we need to deepen a common understanding on how international law applies in cyberspace. That is, I mean, how international law applies is still a subject to debate. Perhaps each case should be considered on its merits. Anyways, I consider that states should, not only states, but here we discuss it later, that all the stakeholders should put in place. But I mean, this is the responsibility of states to put in place relevant policy and legislative measures at the national level first, and then to find a common ground on dimensions how international law could be applied to the whole ICT environment. I guess I will stop here.
Thank you for kicking us off. Before we move to the next question, I'd like to ask Kelly, Vera, if you've got anything that you would like to add briefly to this. Kelly first.
Thank you. Hello, everybody, and thank you very much for the organizers for organizing this event. And I'm really happy to be here with you. And thank you also for kicking off the discussion, and to Mr. Nusupov for his comments. Maybe just shortly to add some thoughts. First, as Estonia has been part of the GGE process as well, then of course we see open-ended working group as an additional layer, as also Mr. Nusupov mentioned, as an additional layer, because now it's all-inclusive international forum for the member states of the UN to discuss in a bigger forum how international law applies. And what we really like to and want to underline is the really main notion that we don't start from zero anymore. We have GG reports, we have statements on how they see that international law applies, which means that we should take this information all into account. So open-ended working group hopefully is a further step in that process. And we really need to build on what already has been agreed upon, so that we don't open up the same discussions, but hopefully move along. And maybe also coming back to the mandate, which was also mentioned, to study how international law applies, then we see a great value in that now we have engagement from all states. And we see this also as an opportunity for capacity building, because we see it also in other forums in international law that there are states who are maybe more progressive, also because they are more involved. For example, I don't know, law of the sea, the countries who are at the sea, they are more engaged. So we see the opportunity that here, as we are all engaged in ICTs, as we are all engaged in cyberspace, that we have this opportunity in this working group to really work together and get this understanding together how international law applies. So because we've also heard this critiques of GG that this is only some states participating, but I think it's a good step forward now to open-ended working group, and we are really looking forward to working there with all the member states. Thank you.
Thank you very much. Vera, would you like to add anything on this point? How to best leverage the mandate?
Yes, hello. Thank you, Cecil. And let me also welcome all the participants of the Cyber Stability Conference. I concur actually with the previous speakers and think that the second open-ended working group can serve really as a platform which has really very good prospects with respect to the clarification of how international law applies in the ICT environment. I think that these endeavors can be guided by two main goals. The first goal can be designated as an interpretive one. So which terms and provisions of international law deserve interpretation? Is it a place for evolutive interpretation of some generic terms? How far can it go, and where are the so-called thread lines for this evolutionary approach? The second goal, I think, consists in the clarification of the issues, which can be solved only by the creation of new binding norms, both of treaty or customary nature. all these efforts can help to reduce the rate of legal indeterminacy and enhance the international rule of law in the cybersphere.
Let me, in fact, then address my next question directly to you, Vera, and just now turning maybe to the normative gaps. Normative gaps have often been said to be inhibiting the rule of international law in cyberspace, the role that it can play. How do you think can the open-ended working group go about identifying gaps in the international law that are applicable to the ICT environment?
I think that the answer to this question has three main prongs. Firstly, which principles should underpin this work of the open-ended working group to make this work really effective? Secondly, how to define what is a gap, and thirdly and finally, how to proceed when a gap is identified. So starting with the principles which should underpin the identification of gaps, I will highlight two of them. The juridicalization of the work of the open-ended working group in this field and ontological neutrality. The juridicalization of the approach means a necessity to turn a political discourse on application of international law into a legal one. It would presuppose and require more precision, namely to turn the discussion from the level of applicability of different branches of international law to the level of application of concrete rules and legal terms. Just to bring an example, it would require a turn from the acknowledgement that the principle of sovereign equality applies in the ICT context to the question of what cyber activities will infringe state sovereignty. The juridicalization will also demand the states to turn from the mode of making official statements to the mode of legal justification. This turn will require disclosing the legal stance or opinion juris behind a particular statement. For instance, when a state articulates that a sustained attack against its banking system, which could cause severe financial damage to the state, leading to a worsening economic security situation for the population, can be qualified as the use of force, it is crucial to disclose how the state evaluates this stance itself. Does this state insist that it is an interpretation of the UN Charter, or itself considers this stance as a lege ferenda contribution to the possible development of international law? The second principle required for the identification of gaps is ontological neutrality. It should be admitted that it was the so-called military paradigm to treat cyber incidents that received the bulk of the attention. It resulted not only in the choice of terminology for the designation of malicious cyber attacks as operations, attacks, or even warfare. As a result, the law enforcement perspective remained on the sidelines, albeit taking into account both the rise of non-state cyber actors and all known difficulties with the attribution of the malicious cyber activities to states, this distortion is really unjustified. Ontological neutrality would demand to set free from the predominantly military paradigm of qualification of cyber incidents. Consequently, the equal treatment of the so-called law enforcement paradigm will help to stop the overstretching of the jus ad bellum or jus and bello norms, and in terms of gaps, will shift the focus to the international human rights law, for instance, criminalization of malicious cyber offenses, and cooperation of states in criminal matters. The second issue, which is relevant for the identification of gaps, is the notion of a gap itself. Is it always a gap in a case when a general principle or a generic term cannot be extended for the ICT context, or when a general or particular rule is lacking? Well, not necessarily. International law is based on the presumption of permissibility, and it is famous Lotus principle, according to which if a particular behavior is not prohibited, it is lawful. Thus, what is pertinent for the open-ended working group to establish is to identify which new rules are needed to change a general permission, for instance, to impose new positive obligations, one another example, or to govern the capacity building. So this brings me to the third question of how to proceed when such a need will be identified by the open-ended working group. For these purposes, I think that the group can rely on one or a combination of several commonly used tracks in international law, the crystallization of a custom, the adoption of a treaty, or a standard setting. For instance, the so-called cyber due diligence does not exist in the form of hard law at the current moment. But states might be interested in advancing this concept in different forms simultaneously, codifying some of its elements into bilateral or regional treaties, or by drafting the codes or guidances, which does not preclude the possibility of a slow formation or crystallization of relevant customary law. And to make a conclusion, I think that the open-ended working group constitutes indeed a unique universal platform that can be used for all these purposes. Thank you.
Kelly, I'll give you the floor also on that to follow up. I mean, what you see as in fact the methodology, the ways in which the open-ended working group can go about identifying gaps.
Just to reflect on also what I heard from Mrs. Rusinova. For us, I would say that the starting point is that there are no gaps in international law that we should address in open-ended working group. So this is not the main issue, and that's why we also don't see that we really need to dig into identifying the gaps. I otherwise totally agree with the methodology that was proposed, but probably not in this context. At least that's how we see it. So for us, what we see that open-ended working group should do and could do is rather to reach an understanding, and if you wish, also to find the willingness to accept how certain provisions in international law, in existing international law, apply in cyberspace. So this is for us maybe a different approach how we see the open-ended working group's additional value. And maybe just to explain what I mean is that we see that international law is technology neutral, meaning that we don't see that adding another domain would mean that we start from scratch and we start from the point where we don't have rules and we have to create them. So this is probably also one of the reasons, or the main reason, why, for example, for us, we don't see a need for a treaty. We don't see a need for example, for the open-ended working group to work on a new draft on any kind of treaty on that. But mainly we see that we need to extend the understanding and talk and have a discussion on that, because I agree that cyberspace has unique aspects comparing with other domains, but it shouldn't be a restriction. It's just another layer of finding out how the existing international law applies. Thank you.
Thank you very much. Asset, still on this question, over to you.
Previous speakers shared very deep thoughts on this dimension. So I have very few things to add, and I will think it's from different standpoint, and I would appeal here to the element of new reality, for example, such as blockchain. Collins Dictionary, lexicographers who monitor 4.5 billion words have chosen the word of this year, which stands for NFT and means a unique digital certificate that registered in blockchain and used to record ownership of an asset. And this word actually has broken through the COVID noise, and I think it could be somehow change the maybe many will affect many lives. So I want to say that if we want to change future, we should start today already by making the right decisions and going more precisely to the issue we're discussing. I think that let's say the issue of legal protection for researchers that make a penetration tests in some states, they already have discussion, and some states will face it maybe in the future. So different stages that some states will face with. Anyways, we need to discuss gaps in the framework of OEWG, and then I think we need to implement precise norms in laws. So states should elaborate these missing puzzles, missing gaps that national legislation is not foreseen before. And then, as the previous speaker mentioned already, I would agree that it's not the ICT themselves, but the operationalization in terms of global system. When you make it like from national standpoint to the global system, this is the main thing that should be enhanced and needs some more understanding and discussion. This is what I think.
Let me turn to our third and last question of the panel. Before then, we open to the questions from the audience. And again, inviting the audience to feel free to please post questions using the Slido platform. As we're discussing public international law, a domain which is traditionally largely reserved to states and governments, we are yet all aware of the role of non-state actors in cyberspace, and in fact, a broad range of non-state actors. So the Open-Ended Working Group itself is also a multi-stakeholder forum. So Curly, turning to you, what do you see as the role of non-state actors in clarifying international law, the international rules applying here? Is there perhaps a role for some of them? Is there also possibly a role for the International Law Commission? So how do we see the group within the larger, the larger set of other actors that could be involved? Curly?
If I may, for clarification, the preference is given to the usage of the term stakeholders or multi-stakeholders, so I wouldn't use the word non-state actors here. But stakeholders, be them private companies, academia, civil society, plays a key role on how we further our understanding on how international law applies. And it's because they play an important role in internet governance in general, in ensuring the maintenance of an open, free and secure cyberspace. So it's not just for the governments, and definitely we don't see that states should govern the internet, but there's the players are the stakeholders are much wider actors. And maybe to be honest, right from the start, we see that during the last Open-Ended Working Group, the limitations which were posed on stakeholder engagement were disappointing. And therefore, we remain one of those who hope that this time around, the access for them is more favorable. And having as many stakeholders participating is essential for a meaningful outcome. And the reason mainly is to have a wider view on the impact and on maybe the sides that the states wouldn't otherwise look upon or wouldn't really go into deep. So we have the stage of wider actors who could really help us see what maybe the states don't put their focus on. And I know that some would prefer informal consultations instead of formal ones, to have them beside Open-Ended Working Group. But I see that informal consultations, as well as any other informal input, is something that we may or we may not take into account, but having them formally at the table is a different story. And then we have maybe a better reason or maybe also a better leverage to work on what they've addressed. And just to give an example on stakeholders' involvement in very informal way or in other events where we could also see that how could we take them into this discussion. For example, we all know Tallinn Manual 1 as 1.0 and 2.0, and now we know that the NATO Cooperative Cyber Defense Center of Excellence has committed to host the third project, which would expand Tallinn Manual 2.0. And this is a very open process, and we see that they are working on now and moving forward to work on the state's behavior and what have been the state's opinions and statements on how international law applies to cyber. But this is something that Open-Ended Working Group may take into account, but may not, because it's a parallel work and those might not be connected at all. And also another example, for example, it was just launched, the final report of the Council of Advisors on the application of the Rome Statute or of the International Criminal Court to cyber warfare. And this is also something that states, the main launcher was Liechtenstein, but there were also 10 other countries who were actively participating and getting together those advisors, which were from universities, mainly from academia. But once again, we see that this is a parallel process, and if we just stay into informal stage or informal inputs, then we may, but also may not take them into account. So we see a real value in having the stakeholders having a formal role in Open-Ended Working Group. And you asked also about the ILC, International Law Commission, which is established by the UN General Assembly. There, I must say, I take a different approach. And reading what the mandate of the ILC is to initiate studies and make recommendations for the purpose of encouraging the progressive development of international law and its codification. And we know that ILC is really working closely with the states in UN 6th Committee. Then this is a bit a different fora, and we see that there's a risk maybe that we have in the UN parallel processes as we had lastly with GG and Open-Ended Working Group. But this is also in terms of international law and really committing to analyzing how international law applies and what is the state practice. Then we see that it's not the perfect time at the moment to take international law in cyberspace into the working agenda of ILC. And the second reason, besides that being a parallel process, is that we are yet in the progress where we ourselves as states try to better understand what are the state positions, how states see that international law applies. But what's needed for the ILC is the state practice itself, so that they could analyze and stem their analysis from that, which means that this could be a second stage after the Open-Ended Working Group, after we have enough state practice, open state practice, I want to emphasize that, so which is available, and then they could work on it, but probably not yet. Thank you.
Thank you. Asset, you may have views on this as well. Over to you.
Yeah, thank you. Let's again refer to OEWG mandate. So it said the General Assembly decided, and OEWG may decide to establish thematic subgroups as the member states deem necessary, with the view to fulfilling its mandate and facilitating the exchange of views among states on specific issues related to its mandate, and may decide to interact as appropriate with other interested parties, including businesses, non-governmental organizations, and academia. So in general, I looked through the International Law Commission, and I think that because recommendations of the International Law Commissions can be used and will be very useful, but since the ILC members act in their personal capacity, I think that ILC decision again will be non-binding. So anyways, the UN, I guess, is the good platform for better inclusivity and exchange of extra views of all stakeholders. So going back to 2019, at the regional consultations, I proposed to develop new mechanisms that will regulate ICT. And so the main point was to to put some special attention to the specialized humanitarian and medical institutions. I wanted to point out that, for instance, we had a very good discussion with ICRC, who was very, I would say, whose contribution to the final reports were very useful to be, I mean, in a practical way. So I think, anyways, we should use all the existing multilateral, regional, any other bodies and other all of the stakeholders to in order to improve this very broad and I would say complex issue. Thank you.
Thank you. And I'll turn to Vera.
To share my opinion, I think that the work of the GDE, of the first Open-Ended Working Group, the compendium that we have now, and also the establishment of a second Open-Ended Working Group are indicative of a very important new trend. And for me as a professor, this trend actually is quite clear. And this is a shift from the so-called managerial approach to the questions related to the application of international law in the cyber context, when primarily experts and academics, like me, for instance, proposed the way and commented on how international law should apply to cyber incidents. And it is a movement from this managerial approach to the consent base, when the states decide. International law was and remains a consent-based order, so only states' consent can give rise to a new rule of international law. Only states' practice matters for the interpretation of existing norms. I think that the willingness of the states to unite their efforts and discuss these issues, very complicated issues, on the basis of a democratic, inclusive, and transparent platform is a value in itself. Indeed, the General Assembly resolution, which established the mandate of the second Open-Ended Working Group, does not preclude the involvement and the possibility to use the expertise of non-state actors like businesses, NGOs, and academia. However, states are the main actors in this field, and I think that should be really appreciated. With respect to the possible role of the International Law Commission, I think that I concur with what was said by my colleagues, and I think that it would not be efficient at the current moment to invite it for the process of clarification of international law or how it applies in the ICT context. For many reasons, they have been already mentioned. Some of them have been already mentioned, but I would add also that I think that such an invitation would be a premature step, as it is now a stage when states themselves should negotiate these issues. And second, it would significantly exceed the capacities of the International Law Commission, with all due respect, of course, to the expertise and the value of the decisions and drafts prepared by this commission. Thank you.
As we were engaged here in the room on those questions, we also have a very active public, and we've received several questions for this panel. In fact, 6 questions. And I'd like to maybe start with one that is one of the provocative questions asked by the audience, which was addressed in particular to one of the speakers, but in fact is really one for all of you. Is there no need for an ICT treaty? The question was asked by Henry Shablin and directing it to you, Curly, but really, is there no need for an ICT treaty? Maybe, Curly, if you can start, and then I'll give the floor to Asset and Vera.
Yes, in our opinion, there is no need for ICT treaty, at least not now, because we don't see yet the reason why there should be one. And probably one of the reasons or main reason is that, is there a gap we should fill? And at the moment, we don't see that there is any, because we are in the phase of making it more clear how existing international law applies. So yes, we don't see a need for ICT treaty at the moment.
I think some sort of the treaty could be considered, since I started to say it before that one of the main issues which I'm concerned in is the implementation of the application of the IHL, International Humanitarian Law, which is very a complex issue in terms of it says, as I before said, it could be applied only in an armed conflict, which means that there are so many things like Martin's Clause, the proportionality and distinction issues, the attribution complexity, and etc. So it's very hard to. We have the Geneva Convention for the IHL itself, and it could be we can consider to adopt binding treaty for the ICT as well. I'm not saying it's going to be easy task to do so, but I think it has the right to be and to live. Thank you.
I think that the answer depends on how you would define the scope of this treaty, so which issues, which matters it could have govern. And I think that here it is anyway a place for the debates and for drafting a new version of the what I call Budapest 2.0 for the treaty, which might be dedicated to the issues concerning the cooperation of states and with respect of criminal matters, and also criminalization of a number of different malicious cyber activities. So as the Budapest is indeed original convention, and not all the regions in the world, they have developed something looking like Budapest. So I mean that indeed this place is free and is looking for states willing to participate in these collective endeavors and in the norm creation process, at least. Albeit, indeed, a number of other issues are always raised in the academia, at least, and some of them indeed can be treated in the form of a separate treaty. For instance, Asset just has mentioned the problem of applicability of IHL to different cyber incidents. And indeed, what we witness and what we can see is that norms of the Geneva Convention or both additional protocols thereto, they contain very general terms, which and some of them are not designed to be applicable to the very specific cyber context. So what can be made here, I would warn from a very far-going interpretation, because here the lines can be indeed passed, and think on whether probably some types of activities deserve precise attention and can be treated separately in a form of a treaty. And I think this is normal for public international law, and therefore, once again, ending with my introduction, I think it depends on how you would define. So what should be what should be governed by such a new international treaty.
I think that one that may also takes us back to some of the important discussion was a question asked by Amir Mokaberi, who asked whether, considering the role of the private sector and especially big tech in infrastructure management, whether in fact the businesses and the private sector shouldn't have responsibility and obligations under international law. And so the question is really whether that they can have obligations directly under international law. Vera, would you like to kick off with that question?
I think that it has two different layers. The first one is actually whether we can speak and discuss responsibilities, duties, and obligations of businesses in terms of primarily due diligence or non-binding obligations. So something that would push businesses to actually to participate in the process of fostering the cybersecurity. And here, absolutely generally speaking, I think that in general, public international law is moving towards the acknowledgement of a more responsibility of businesses. And for me, as a scholar, for instance, the judgment of the Canadian Supreme Court adopted in 2020 on Nifsun case, it was a revolution because the court has actually find out that a private company, corporation, is bound by the duties to respect basic human rights, so by international law directly. So nonetheless, it was and remains rather a revolutionary finding for the rather conservative understanding of the place and role of the business. But should we speak about the second layer, which is the development of different non-binding rules at the international level, and sometimes binding rules at the national level, dedicated or actually requiring business to undertake due diligence? I think through these instruments already now, a number of states, 5, if I'm not mistaken, plus partly European Union, are requiring from big business to undertake human rights due diligence. So and finally, indeed, what can be discussed, whether what should we do actually with some private initiatives dedicated to the either directing or addressing the states or pushing the states to do something in this sector, or regulating the as the layers they stay outside the currently applicable international law. So I think here we already have a number of different initiatives, but I would be very careful with their evaluation. And I think that that indeed the business already has found it very important and necessary to be a responsibility, not only for governance of particular issues, but also to making and implementing technical decisions, so what we call security by design. So actually it's already going on, and I think it's not only laws that pushes businesses to do so, not only the state, but also the market, and also the reality that we face nowadays with so many cyber incidents taking place each day. So I will probably end up with this.
In your answer, you also brought the issues of due diligence and security by design. So I wouldn't be surprised if Asset or Kelly want to also comment further on that, or Asset, anything on this?
I agree that this is one of the important issues to discuss, and I think that the specific norms should be provided for this issue for some technological companies. But I don't know how it's going to work. Like if we build the list of firms, then it's somehow they will change, and the market will change, and they will disappear, and we will have to change legislation, which is very complex process. So I would say that the right example is the recent taxation thing that happened for the IT companies, which are obliged to pay, I think, none less than 15% of their profits for the when they're based in the country. So this is a very broad question, and we discussed it through the critical infrastructure issues, or when some critical infrastructure objects belong to a private sector and supply chain and etc. And I think this question is related more to the attribution. For instance, if the cyber incidents happen somewhere in some country, and maybe state is not responsible for this cyber incident, at the same time, any private company could be responsible, but it's private company, and this is public sector, which is different. So somehow we need to regulate this. I mean, this is a good point. Thank you.
We are aware of those discussions, and of course, this is a very interesting avenue where we are heading if we talk about international law and private companies. But at the moment, I would say that we are still looking at the states and how states regulate internally. What's the national law? And even if we say that states are responsible, then one part of the responsibility is to regulate nationally so that your private companies wouldn't breach the law. So there has to be the law. And I think that this is the way how it's going to stay for quite a while, because as was mentioned already before, it is a tricky situation to combine both the states and the private companies in international law. I would think that it's going to stay for a while that we do that through states and through states' responsibility. Thank you.
Marcelevich, who asked whether the work that is ongoing on science-based principles of global systems of norms on ICT and artificial intelligence, including external contributions, also in cooperation with the ITU and WIPO, are also being considered. So I think a question there that is really looking as to whether the open-ended working group, the GGs, are also branching out with other types of norms. Is that something, Asset, clearly in light of your own involvement, you would like to take? Asset first?
I think that this is new, evolving, emerging technologies are most likely to be considered in the threats section, I would say. But as for artificial intelligence, this fall, it was somehow, I remember that it was prohibited by the UN to use it for the, if it's against, once it's collecting some very personal information, I consider. So I think we have like we have almost 4 years ahead, and technologies, they change very rapidly. So this could be considered within in the framework of the mandate of the OEWG again, but there are so many issues to discuss, but I think this thing as well could be among them, I mean, in the list. So we'll see how it works.
It comes back to all the stakeholders that could be involved, and as the modalities of how all the stakeholders could be involved have to be agreed upon in the first session of the open-ended working group and by consensus. So it remains to be seen how it could be done officially, at least in the beginning. But my hope as a lawyer, if I may say so, is that, as was mentioned also, artificial intelligence, this is discussed in very many different international organizations, in different forums. So my hope would be, of course, that at some point we bring all those different discussions together, the outcomes somewhere together. And of course, open-ended working group could be as it is in the UN, the global working group, I would hope that we could take into consideration everything which has been discussed also, for example, in ITU or WIPO, as was mentioned. But let us see, because yes, it is a difficult process. It's a long process, so we'll see. Thank you.
Nobody excludes that possibly the expertise of other international organizations would be needed, and at any point, I think that any international lawyer or a lawyer dealing with issues concerning ICT and application of law to the ICT actually sticks to the number of questions that are very technical, let's say, and complicated to conceive. And here, indeed, the expertise will be very important to receive and to be guided, or at least to be learned. Therefore, just thinking on this science-based approach, I would suggest and think, being an outsider from this for this process, that I indeed trust that all the decisions, all the discussions will be driven by knowledge, and where it will be necessarily also by the science-based knowledge, not only law. So lawyers do know law, but they do not know everything.
We're now approaching the end time for this panel, so I'd like to wrap up. And in doing that, I would like to give you each, again, our panelists, the floor for like 1-2 minutes maximum to wrap up, and maybe to wrap up on really whether, in fact, what should be a reason for us to be optimistic in terms of where the process is going, or any other final thoughts that you may have. So let's start with you, Vera. Any final thoughts as we wrap up?
My conclusion is very optimistic, probably. So let's be optimists. And I think that although the opinions that have been expressed during our panel were slightly different, so not unanimous probably, but also this exchange, this intellectual exchange also demonstrated that there are a number of points where we are very thinking in the same direction. And I think that is what unites also the states participating and favoring all the work of the Open-Ended Working Group. Actually, this format is the idea that the compromise is needed, that it is to be appreciated, and that the compromise is feasible to be reached. And I think that everybody of us, not only lawyers, but ordinary people will actually gain from this effort. So we are looking forward, and we'll be waiting for the results, hopefully precise, concrete, and indeed based on a wide consensus from the Open-Ended Working Group.
In general, I would say that the involvement of the international community is increasing, and this is very good, and this facilitates the common understanding. So if many states, many people are engaging, for instance, listening to this conference and participating at the OEWG sessions, events, regional conferences, any confidence building measures. So all this leads us to the common ground, to the common understanding of the processes we are involved in, and how to deal with them, and how to implement them, how to wrap up them into the some legal binding and measures in order to everything will work like in a proper way. So hopefully we will manage this, and by the end of the work of the 80th session of the General Assembly, we'll have a very deep and very, I would say, considerable document that will change our life. Thank you.
I'm an eternal optimist. So also in terms of Open-Ended Working Group, having this all-inclusive forum, I want to be optimist in saying that we see that the questions on how international law applies in cyberspace and what's the state's responsibility, due diligence, all those questions, we see that now when we have a broader audience and participants, there is this possibility that we not only find a consensus or a common understanding, but first that we really build the capacity for understanding and for really going into deep discussions, because we have then the opportunity first to identify in more specific way, in more detail, the provisions that we need to talk about and also the questions that will come up in the open-ended working group. So this all-inclusiveness and capacity building and taking that all into consideration, I am optimistic that we go further, we find a better understanding, and also my main hope would be also the willingness of the states to then really apply and adhere to what we have found out in our discussions, if I may say so, the findings, how international law applies in cyberspace. So thank you.
Excellent. Thank you very much. So again, our three great panelists, Ms. Kerliversky joining us from Estonia, Mr. Asset Nusopov joining us from Kazakhstan, Professor Vera Ruzinova joining us from Russia. Thank you very much to all three of you. And this closes this panel. Over to you.